Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us, coming to you from our fantastic Central Washington location. Check that out back there. Hey, you know, one of the best things about doing Washington Gun Law is reading all the comments, listening to all the viewers and what they got to say, and seeing the different stratification of belief systems that many of our viewers have. And there is a segment of you who believe that every single gun law, no matter what that law is in fact unconstitutional, including the existence of having to go through a background check even to purchase a firearm. There are some of you who believe that the Form 4473, a form that we are all abundantly familiar with, is actually unconstitutional. Well, guess what? A court recently had to make a ruling on exactly that, and we're going to geek out about it today. And since you haven't heard about it yet, you probably know how it went. But today, let's spend a few minutes and let's talk about court determines if Form 4473 is constitutional. Okay, before we get going too far down the road we're going down, proud to announce that this video is being brought to you by Right to Bear. That's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have Right to Bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com. Okay, America, this is what we're talking about today. We're talking about the case of the United States versus Scheidt. This is a case that originates out of the state of Indiana. It was originally filed in the United States District Court for the Northern District of Indiana. This is a ruling from a 3-judge panel in the 7th Circuit, which has found that the Form 4473 is in fact constitutional. As a matter of fact, the court has found that the Form 4473 does not even implicate the Second Amendment at all. Now, there's an old adage that bad facts make for bad law, and this is a classic example because Echo Scheidt, who lived in Indiana, purchased 5 separate firearms but lied on each one of the 4473 applications using a fake address or former address. Those firearms were then sold to other individuals, and those firearms shockingly turned up in crime scenes. When law enforcement went on a trace and traced them all back to Echo Scheidt, they found out that that individual had in fact lied on 5 separate Form 4473s, was indicted under 5 counts of violation of 18 United States Code Section 922A6, which of course makes it a felony to lie on a Form 4473. Now, if you really kind of want to know where the court was coming from, check out this paragraph right here. By its terms, Section 922A6 prohibits making false statements in connection with the acquisition of any firearm from a licensed dealer with respect to any fact material to lawfulness of the sale or other disposition of such firearm or ammunition. Nobody disputes that the statute covers and prohibits Scheidt's submission of false information on ATF Form 4473. Plain and simple, she violated Section 922A6 foremost when she knowingly lied about her home address. And then the court begins to point out that they're not particularly persuaded by the defendant's arguments here. Scheidt urges us to see her appeal as raising a constitutional issue, whether the Second Amendment framework the Supreme Court adopted in Bruin applies to false statements like Section 922A6. Her argument goes like this. Scheidt implores us to see her prosecution as covered by the Second Amendment because Congress conditioned her right to purchase a firearm on completing ATF Form 4473. Section 922A6, she adds, further conditioned her right to possess a firearm by demanding honesty. The district court committed error, Scheidt tells us, when it failed to undertake the Bruin-mandated historical analysis and thus to determine whether our nation has a history and tradition of requiring the completion of registration forms prior to sale. But you see, The Seventh Circuit panel came down and said, listen, we don't even see that the Second Amendment is implicated here. They ruled as follows. We disagree and do not see this as a Second Amendment case. Ordinary information providing requirements, like those imposed by ATF Form 4473 and enforced through criminal statutes like Section 922A6, do not infringe on the right to keep and bear arms. Completing ATF Form 4473 and adhering to its attendant truth-telling requirement is conduct that is outside the scope of the Second Amendment's protections, not requiring application of Bruin's historical analysis framework. But of course, the defendant is saying, hey, but the 4473 is an impediment to actually being able to exercise an inalienable right, correct? Wrong, according to the three-judge panel of the Seventh Circuit. Scheidt urges us to see ATF Form 4473 as akin to condition precedent that imposes an unconstitutional barrier to individual gun possession. We decline. Neither the form nor the requirement to complete it impose any sort of unconstitutional condition under the Second Amendment. Rather, ATF Form 4473 helps screen for purchasers who run afoul of regulations informing who may lawfully possess a firearm and what kind of firearm that person may possess. The plain text of the Second Amendment does not cover Scheidt's conduct, so there is no need to conduct a historical analysis of gun regulation forms. And listen, relying on previous precedents, a case called United States v. Holden, the court basically said, listen, this is not about Second Amendment protections. This is about a requirement, a statutory requirement, that if you're going to fill out a federal form, you're honest about it. And if you willfully lie on a federal form, under the penalty of perjury, which a 4473 is signed under, then that is a violation of that statute. And the crime is not trying to obtain the firearm. What the court is saying is it has nothing even to do with obtaining a firearm at all. The crime is being less than honest on the form. Listen, I know many of you believe that the whole Form 4473, the Form 1, the Form 4s are all unconstitutional. Perhaps that is the case, but we're going to need a much better set of facts to make a challenge than what was presented in this case. The case, once again, is United States v. Scheidt. We're going to go ahead and link it up down below so that you guys can all geek out on it for yourself. Hey, maybe you got some ideas for videos we should be doing here at Washington Gun Law. If you do, go ahead and click on that link right there. Some of the best ideas we had really weren't our ideas to begin with. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. If you don't, that information's down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.